You're watching Twistedcase, measured, fact-checked crime storytelling. If you value calm reporting without hype, consider following for more. A man at a printer. A flyer about killing judges. Staff read the words, make a call, and start a paper trail that turns into federal charges. Plus. Wayzata Library is a normal civic space. Computers, printers, community tables. On September 3, 2025, it becomes the first scene in a federal case. Staff notice a patron printing a long manuscript and handing out a 3-page flyer that promotes it. The flyer's language is alarming enough that they contact law enforcement. Subject. The patron is Robert Phillip Ivers, 72, a Minnesota man with a prior federal conviction for threatening to murder a judge in 2019. That earlier case matters because it sets the context for what follows and explains why authorities take the library incident seriously. The earlier conviction resulted in an 18-month sentence and supervised release. What staff see? Ivers is printing and promoting a 236-page document titled, How to Kill a Federal Judge. The flyer markets the manuscript as a guide for extremists and includes bleak predictions about judges being killed. That's the first break in the story, from concerning behavior to a formal response. Initial arrest and complaint. After the library call, federal authorities take Ivers into custody and the U.S. Attorney's Office files a criminal complaint charging him with threatening to assault and murder a federal judge, 18 U.S.C. Section 115A1B. This lays out the probable cause, the printing, the flyers, and the content of the manuscript. The complaint is the system's first, formal entry in the record. During the investigation, agents search Ivers's vehicle. They report finding multiple printed copies of the manuscript, about 20, along with other items that suggest fixation on the judiciary. Those items include a replica firearm and lists of judges. These details matter because they shift the incident from words on paper to a picture of preparation and targeting. A brief gap in custody. After the first arrest, Ivers reports a medical issue, is transported to a hospital, and is then rearrested days later. Whether that interlude reflects manipulation or a real health problem is not something the current filings resolve. The key point for the timeline, custody resumes, and the case moves forward. The manuscript. Prosecutors describe the 236-page document as a manifesto that instructs or encourages violence against judges. The title is explicit. Portions allegedly include references to killing children and show a gun image. Even without a single named target on the title page, the topic and framing are specific: how to kill a federal judge. This is the central evidentiary object of the case. The flyer. Staff say Ivers was handing it out at the library. The flyer markets the book to potential readers and uses language that, according to charging documents and coverage, signals a call to action for extremists and claims judges are going to die. Flyers in public spaces matter legally because they spread the message and can turn private writing into public promotion. Days after the complaint, a federal grand jury returns a 3-count indictment. It expands the scope. Count 1. Threatening to assault and murder a federal judge. Count 2. Threatening to assault and murder a U.S. Supreme Court justice. Count 3. Interstate transmission of threats to injure others, including a defense attorney. The government asks for detention. A judge orders Ivers held pending further proceedings. About the Supreme Court justice. Prosecutors' public documents do not name the justice. Ivers's attorney, however, tells reporters the alleged target was Chief Justice John Roberts. That's an attorney assertion, not a named target in the indictment, and should be understood that way until or unless it appears in court filings. Not guilty. Ivers plans to plead not guilty. His attorney signals a First Amendment defense. The manuscript, they say, is vile but protected speech. They also note that the manuscript has appeared before as a government exhibit in prior proceedings, and question why printing or promoting it now triggers new charges. This previews the trial's central dispute: when do violent words cross the line into a true threat? Why this distinction matters. U.S. law protects a wide range of offensive speech. But there's an exception for true threats, statements that, viewed in context, communicate a serious intent to commit unlawful violence against a specific person or group. Prosecutors will argue the title, the flyer's sales pitch, The prior conviction, the lists of judges, and the distribution effort show intent and targeting, not just ugly rhetoric. The defense will argue the opposite: no concrete plan, no specific actionable steps, and protected, if repugnant, expression. For context on Ivers's earlier conviction and the statutes involved, 18 U.S.C. Section 115 and Section 875C, see the Supreme Court filing recounting that case. The 2019 conviction. In the earlier case, a jury found Ivers guilty of threatening to murder U.S. District Judge Wilhelmina Wright. He served 18 months and later lost his appeal. That history is likely to be central in detention and, to a limited extent, at trial, subject to evidence rules, because it ties current speech to past conduct of the same kind. Other encounters with the system. News coverage also notes later incidents involving threats toward judicial or law enforcement personnel. Some of those charges were resolved or dismissed, others contributed to a pattern of concern. The takeaway for viewers is not to pre-try those facts, but to understand why probation officers, marshals, and prosecutors treat new warnings urgently when they involve a person with a documented threat history. Rising threats. The Ivers case lands during a documented increase in threats against the judiciary. Reporting citing the U.S. Marshal Service places the figure in the hundreds for fiscal year 2025, over 500 incidents recorded. This is why a flyer in a library travels quickly through law enforcement channels. Institutions have become more vigilant because the volume of threats has climbed. Why this matters to the public. Judges, their families, and other court personnel have changed routines, security at home, package protocols, varied commutes. When threats become common, the costs of public service increase in ways the public rarely sees. That context does not convict any one defendant, but it does explain why the system errs on the side of caution when a person with a prior threat conviction appears to be promoting violent instruction again. Step-by-step timeline. September 3, 2025, Library Incident. Staff at Wayzata Library see Ivers printing the manuscript and handing out a flyer. They notify authorities. Police respond. Same day, arrest and search. Ivers is taken into custody. A vehicle search recovers about 20 copies of the manuscript, a replica firearm, and lists of judges. Some reports also mention fireworks and a BB gun. The exact inventory varies slightly across outlets, but the replica weapon and judge lists appear in multiple reports. September 3 to 6, hospital release and rearrest. Ivers reports a medical emergency, is taken to a hospital, released, and then rearrested within days. September 9, federal complaint filed. The U.S. Attorney's Office announces a complaint charging Ivers with threatening to assault and murder a federal judge. Detention is requested. A 3-count indictment adds alleged threats against a Supreme Court justice and interstate threats against a defense attorney. Ivers is ordered detained pending further proceedings. September 12 to 13, media updates. Reuters reports the defense attributes the Supreme Court count to a threat against Chief Justice John Roberts. That detail is not in the indictment and is attributed to counsel. The statutes. 18 U.S.C. Section 115A1B makes it a federal crime to threaten to assault, kidnap, or murder a U.S. official, including a federal judge, with the intent to impede, intimidate, or retaliate against them on account of their official duties. 18 U.S.C. Section 875C covers interstate transmission of threats to injure. In Ivers's 2019 case, those are the counts that led to conviction. In 2025, prosecutors are again relying on Section 115 and Section 875C, now tied to the manuscript, flyers, and alleged distribution efforts. Courts will look at context, prior behavior, specificity, audience, and whether a reasonable person would read the statements as a serious expression of intent to inflict harm. How true threat is judged. Jurors are typically instructed to consider the words in context. Who said them? To whom? How, where, and when? What else supports or undermines intent? In threat cases built on speech, prosecutors rarely have a seized bomb or a booked travel plan. They must prove that the communication itself is a threat, not merely fantasy or political hyperbole. The defense will stress the difference between fiction and plan. The state will point to target lists, promotion to the public, prior convictions, and the title itself as evidence that this wasn't satire or art, it was menace. This is a person with a daily routine, hearing cases, writing orders, who now has to adjust home security and travel habits. Even when the press withholds names, the impact is personal and immediate. The system assigns U.S. Marshals to evaluate risk and coordinate with local authorities. The Supreme Court Justice. An indictment referencing a threatened justice raises the profile and urgency. Without naming the justice, the allegation alone changes the security posture because national leaders carry different protective protocols. Again, the indictment does not name the justice. The defense told reporters it was Roberts. Treat that as a claim by counsel unless filings confirm it. The defense attorney. Threats against defense lawyers are threats against the right to counsel. The indictment's third count alleges interstate threats directed at a defense attorney. That widens the alleged harm beyond judges to the broader legal system. The library staff. None of this happens without employees who read a flyer carefully, trusted their instincts, and documented what they saw. They are the first link in the chain from observation to intervention. The flyer lands on a public counter. A staff member reads past the headline. A call is placed. Officers arrive. A search begins. A manuscript and copies are recovered. A complaint is filed. An indictment follows. This is what it looks like when a threshold is crossed in real life. Just a sequence of decisions that starts in a quiet room and ends in federal court. Pre-trial motions. Expect the defense to file motions challenging detention and the sufficiency of the indictment, and to argue that the speech is protected and not a true threat. The government will counter with context, the prior conviction, and the materials recovered. Discovery and expert testimony. In speech-based threat cases, parties sometimes present experts on extremist communications or risk assessment, and introduce evidence about how targeted officials interpret such messages. The court will manage how much of Ivers's past can be shown to a jury under evidence rules that limit prior bad acts, unless they prove motive, intent, or similar non-character purposes. This is general procedure context. Specific filings will set the boundaries. Possible plea versus trial. Many federal threat cases resolve with a plea if the parties agree on facts and sentencing range. If not, expect a trial focused on intent and context more than on physical acts. The jury question usually boils down to, did this communication, in light of everything around it, convey a serious intent to commit violence? Climax of the current record, a 3-count federal indictment and a detention order holding Ivers pending further proceedings. That is the decisive point reached to date. It doesn't answer guilt or innocence. It marks the formal escalation from suspicion to charged crime. We can hold two values at once. Free speech must be broad. True threats must be punished. The line is hard to draw, and drawing it carefully protects everyone, especially dissidents and critics who rely on the First Amendment. This case will test that line. Institutions can learn. Rising threat numbers have pushed courts and prosecutors to move faster. A flyer in a public building is treated as a distribution act, not a private diary. Speed here is not theater. It is risk management based on trend data. Humans make the difference. A librarian reading a page closely. A marshal running a risk assessment. A judge signing a detention order. These are ordinary decisions that together prevent extraordinary harm. Charging documents from a U.S. Attorney's Office, District of Minnesota, confirmed the complaint on September 9, 2025, and the indictment on September 12, 2025, including counts involving a federal judge, a U.S. Supreme Court justice, and a defense attorney, and that Ivers is detained pending further proceedings. Reuters reporting summarizes the arrest at the Wayzata Library, recovery of multiple copies of the manuscript, replica firearm, and lists of judges, and includes the defense assertion that the justice was Chief Justice John Roberts. It also places the case within a national rise in threats, 500+ incidents. Washington Post coverage provides additional detail about items recovered, including fireworks and a BB gun, and notes Ivers's broader history of concerning conduct. Prior conviction and statutes are documented in a 2021 Supreme Court filing and a 2028 Circuit Appeal report. They confirm the earlier 18-month sentence and legal bases, Section 115 and Section 875C. Where would you draw the line? If a person with a prior threat conviction prints a manual titled, How to Kill a Federal Judge, and distributes flyers in a public library, is that protected speech until a concrete plan appears? Or is it already a true threat that demands early intervention to protect judges, attorneys, and the rule of law? How do you balance maximum speech protection with real-world safety for people who serve in our courts? Share your view and your reasoning respectfully.
Let us know your thoughts in the comments below. Subscribe for more gripping true crime breakdowns, mysteries, and criminal psychology stories, only on Twisted Case.